Welcome everyone to our latest webinar. I'm Jeremy Glover, a partner here at Fenwick Elliott. We started our webinar series back on 14th May, and as you may recall, we started with an adjudication update. Now, a lot has been happening in the adjudication world, and so although just 2 months have passed, there's a lot to talk about this morning. Fortunately, I'm joined by two people well qualified to assist. First, my colleague Martin Ewen, who became a partner here in April and is also Secretary of the Adjudication Society. And second, Melissa Shipley, Counsel of 39 Essex Chambers. Melissa's a rising star of the construction bar, and she's been involved at the coalface in a number of adjudication enforcement hearings at the TCC, both reported and unreported. So you can see today's agenda. We're going to be looking at adjudication in 2020. We'll talk about the Bresco case, but we'll also look about other things that have happened over the last 2 months, crystallization of disputes, issues in relation to severance. So what's been happening in adjudication in 2020? Well, we thought we'd start with a quick update from our first adjudication webinar. Now, it's all right, I'm not going to ask you questions, it's not a test. We just wanted to refresh the issues that we looked at before. We talked about the importance of getting the formalities right. And we did that in the context of the adjudication notice, the absolutely key fundamental part of the adjudication process. It sets out what's in dispute. It sets out what the jurisdiction of the adjudicator is. And it's important that it's served correctly. And it's important that you know when the date of service is. And the date of service is usually when the addressee, the adjudicator, receives the document or is deemed to receive the document, taking into account the rules in the contract. We also looked at without prejudice documentation. Now, as a general rule, don't include without prejudice documents in your supporting documents, whether it's the referral or one of the reply submissions. You shouldn't do that. There's a risk, a real risk, that the adjudicator won't have jurisdiction to consider your decision. But we did look at the Transform and Balfour Beatty case, which is one of the exceptions to the general rule. Now, if the issue of the without prejudice letters went to the core, one of the fundamental issues in the adjudication, then it's possible that the adjudicator may be able to look at those letters. We also looked at applications for a stay in execution. Now that's when a party looks to enforce an adjudicator's decision, and they're met by a request for a stay on the basis that there are difficulties with the financial position of the party seeking to enforce the adjudicator's decision. Now, if you're going to make an application for a stay, you've got to act promptly. You've got to act with diligence. But I think by and large, what we've seen, certainly what I've seen, and I think what we've seen at Fenwick Elliott over the last 3 or 4 months, is that adjudication has pretty much continued as usual. And that's what the TCC expected. We talked last time about the Milchrist decision, where the TCC was saying, well, they expected parties to be sensible and take reasonable steps to ensure that adjudications could proceed. And I think pretty much that's what's happened. And the other case that we looked at in our first webinar was the ISG and platform adjudications. Now, one of the issues that was live there was the issue about reserving your position when you pay the adjudicator's fees. It's a simple thing, but it's a very important thing that you should do. Otherwise, you might affirm that adjudicator's decision, and you might lose the right to challenge it. But the ISG and platform decision has been one of those multiple cases, and there have now been 3 decisions in the TCC, and the third one was the end of May, so after our first webinar. So our first update point relates to Part 8 proceedings. And these are proceedings brought to get the court's interpretation of a matter of law, or possibly what part of the contract means. Now, if you're going to use Part 8 to resist enforcement of an adjudicator's decision, you must do so by ensuring that the issue you raise is a short and self-contained issue, which actually arose in the adjudication itself. So what else has been happening in the adjudication world since 14th of May? Well, the CIC have issued some updated guidance notes. You'll see on the screen where on the CIArb has issued some updated guidance notes. And you'll see on the screen where on their website you can get a copy of the notes. Don't worry about jotting it down. We'll give you a copy of the slides after the webinar. Now, I was on the drafting committee which worked on the update, but please don't let that put you off, because it's a really good resource. It sets out the basic principles of adjudication. Now, more recently in July, there have been two resounding affirmations of the value and importance of adjudication by Lord Briggs and Lord Drummond Young. Now, Lord Briggs, in the Bresco case, which Martin is going to talk about, talked about the importance of the availability of adjudication. He thought it was important because it meant that many disputes are speedily settled, whether by the adjudication itself or pre-adjudication or just after the adjudication. And then in Scotland, Lord Drummond Young, in the Dickie Moore case, which Melissa is going to be talking about, he highlighted the value of the scheme. He noted that the fundamental point that the procedures used, the scheme itself, they're intended to be simple, straightforward, and immediately effective. And what he meant by that was that they were simple, straightforward, and they should be immediately effective. Now, I think that the view of these two judges, it's a point of some interest, particularly at the moment, because the general view seems to be that, at least in the short term, one of the results of the coronavirus, the COVID-19 pandemic, is that there are going to be more disputes. The British Institute of International Comparative Law, it talked about a risk of there being a deluge of litigation and arbitration. And I think they've now had a couple of concept notes. And one of the things they were looking for, the alternatives to litigation, alternatives to arbitration. And I think with construction, particularly if you think about the endorsements and the words of Lord Briggs and Lord Drummond Young, with adjudication, we're well placed to pick up those disputes. So you keep people out of the courts, keep them out of arbitration. And it's worth noting that TEXA and the CIC have both introduced low value dispute schemes to deal with the smaller disputes, to try and deal with those more cheaply and more proportionately. And of course, it might be that one result of the Bresco decision, which Martin is going to talk about now, is that there are going to be more disputes too. So Martin, over to you.
Thank you, Jeremy, and hello everyone. As Jeremy said, I'm going to talk about the Bresco decision and the Michael J. Lonsdale, which was in the Supreme Court, with a decision handed down on the 17th of June this year. The Supreme Court is the highest court in the UK, and this is only the second time that the Supreme Court has dealt with a matter of adjudication business. This is a landmark change in the law, and it's important for quite a number of reasons, some of which we'll touch on later. But briefly, now an insolvent party can commence adjudication proceedings at any time, whereas previously it could not. And there's going to be significant cost savings for insolvency practitioners seeking to resolve disputes on behalf of insolvent construction companies by going down the adjudication route. Also, with the current economic climate, as we emerge from the COVID-19 pandemic and potentially into a looming recession, it's likely to be a greater instance of construction insolvencies, and therefore the method will be required to resolve these, and adjudication is likely to be the primary option. Jeremy mentioned I was the Secretary of the Adjudication Society, but I just need to correct that and say I'm the Treasurer of the Adjudication Society, so apologies if the Secretary is listening in. But here, the Adjudication Society excuse me, produces an annual report, which it has done for the previous 21 years. We can see emerging trends in the Adjudication Society report. I've extracted some of the recent years and put the table in this slide from year 16 to year 21. And we can see that from year 16, there were 1,282 instances of adjudicator nominating bodies appointing adjudicators, whereas year 21, well, that has increased to 1,905. Now, this excludes adjudications whereby the parties have reached agreement on who the adjudicator should be, and therefore do not need to seek recourse to an ANB for an appointment. The Adjudication Society research revealed that over 90% of these adjudications were payee versus payer, so a party are looking to be paid. So I think with the increase in construction insolvencies, which is sadly quite likely as we emerge from the COVID-19 pandemic, I think it will be interesting to see what future trends hold, but I would predict quite significant leaps over the next year or two. So back to Bresco, and just to give you some background on the Bresco case. So Bresco carried out works for Lonsdale on a project at St James's Square in London under a subcontract. Various disputes arose on the project in relation to monies due, allegations of wrongful termination, and repudiatory breach of contract. The contract came to an end in December 2014, and in March 2015, Bresco went into liquidation. It was quite some time later, in June 2018, that Bresco's liquidators sought to refer disputes to adjudication. The case came before the Technology Construction Court before Mr. Justice Fraser, with Lonsdale applying for an injunction to prevent the adjudication going ahead on the basis of Bresco being an insolvent company. The court framed the issue for it to determine as this, and that was whether a company in liquidation can refer a dispute to adjudication when that dispute includes determination of a claim for full sums paid to be due to the referring party from the responding party. Now, Mr. Justice Fraser found that there was no longer a dispute under the contract. With the insolvency, the dispute became about the net sum due, that to be determined in accordance with the insolvency rules, and in particular, Insolvency Rule 14.25. As such, he decided there was no longer a dispute under the contract, therefore any adjudicator's decision would be incapable of being enforced. He therefore granted the injunction. The matter then proceeded to the Court of Appeal, with Lord Justice Coulson giving the leaving judgment. Here, Bresco sought to set aside the injunction. The two issues the Court of Appeal considered were as follows, and that was whether an adjudicator can have jurisdiction where the claimant is insolvent, and if so, would that decision be enforced? The Court of Appeal found that there would be jurisdiction and that the claim still existed. The court was influenced in reaching this view based on the fact that claims in litigation and arbitration could still be pursued under the contract, and it did not see why an adjudication procedure or claim should be treated any differently. It therefore agreed with the Technology and Construction Court of First Instance. In paragraph 35, Lord Justice Coulson said that technically the adjudicator would have the jurisdiction to consider the claim advanced by a company in liquidation. However, the decision would not be enforced. The reason for that was because the insolvent company would be unable to enforce an adjudicator's decision. Now, this is due to its financial position, and it goes back to the principles laid down in the decision in Wimbledon Construction and Vago, which makes it very difficult for an insolvent party to enforce an adjudicator's decision. In paragraph 54, Lord Justice Coulson said that even though the adjudicator may technically have the necessary jurisdiction, it is not jurisdiction that can lead to a meaningful result. And he described it as an exercise in futility. And he also referenced the fact that the parties would be incurring costs, and it may also be a potential waste of the court's time. The appeal was therefore refused, and Bresco appealed again. However, after the Court of Appeal decision, but before the Supreme Court decision, we had a case of Meadowside Building Developments and 12-8 Hill Street Management. This was an application for summary judgment. The importance of this case is it set out exceptions where an adjudication could take place, and these have become known as the Meadowside exceptions. And they are where an adjudication determines the final net position between the parties, and importantly, satisfactory security is provided. So this would be security for any sum awarded in the adjudication, security for the costs of any unsuccessful attempt to enforce the decision, and security for costs of any subsequent litigation. The exceptions were not met in Meadowside, and summary judgment was refused. One of the main reasons the exceptions were not met was that the funding agreement that was proposed was unenforceable. After Meadowside, but again before the Supreme Court decision, we had the case of Balfour Beatty Civil Engineering and Aztec Projects. This case was important because it was the first case to apply the Meadowside exceptions and allow the insolvent party to adjudicate. There were two issues decided in this case, and that's whether the final net position could be reached when there are 3 adjudications under 3 separate contracts. The court had no issue with that and said yes. The second was whether the adjudication should proceed by Aztec being an insolvent company. Here, Aztec provided security through an insurer, and unlike in Meadowside, was able to meet the requirements. Therefore, in this case, the injunction was refused. There were, however, some conditions attached, and that was that the same adjudicator had to be appointed for all 3 adjudications, and another key condition was that Aztec had to provide security in the sum of £750,000. Now, if that security looked at any point that it was going to be insufficient, Balfour Beatty had the right to seek further security. So as you can see, there's quite a high bar set here. There were substantial sums in dispute. Aztec were claiming £4 million, and Balfour Beatty were saying that there's a net sum due to it of £1 million. So there's quite a high bar set. As you can see, it's potentially only where there are significant sums in dispute that this might be the appropriate course of action. So we come on to the Supreme Court decision in Bresco, the lead-in judgment handed down by Lord Briggs. To recap, in this case, Bresco sought to lift the injunction, and Lonsdale cross-appealed seeking to restore the TC's decision that the adjudicator had no jurisdiction. The Supreme Court dealt with the cross-appeal first and agreed with the Court of Appeal and said there was still a dispute under the contract. The Supreme Court said that the dispute under the contract did not melt away, so there was jurisdiction. The cross-appeal was dismissed. The Supreme Court then turned to the issue of futility and whether the adjudicator's decision related to a company in insolvency would be incapable of being enforced, or whether it was an exercise in futility. The Supreme Court said that unenforceability does not equal futility, therefore it disagreed with the Court of Appeal. In these slides, I've quoted some extracts from the judgment, in particular on futility, and as Jeremy said, the slides are available, but I'll just make a few points during the course of this presentation. In paragraph 67, Lord Briggs said that the proper answer to all these issues about enforcement is that they can be dealt with at an enforcement stage. So the Supreme Court was relatively untroubled by matters of enforcement and considered, as I say, the time to deal with those and discuss those was at enforcement stage. Lord Briggs also made the point that where there's an issue as to security being provided, then the court would be astute to refuse summary judgment. So similar in principles to the William and Vago principles. Lord Briggs was quite firm in paragraph 71 in saying that adjudication was not an exercise in futility in these circumstances. Paragraph 59, Lord Briggs emphasised the important fact that the adjudication was a statutory and contractual right to the parties. They had that right to adjudicate, and that the court should be slow to use injunctions to somehow interfere with that right. Further on point of futility, Lord Briggs said that there was no answer to the utility of construction adjudication, to say that the adjudicator's decision is unlikely to be summarily enforced. Again, the emphasis on dealing with points with regard to enforcement at the enforcement stage, allowing the insolvent party the benefit of the statutory right or contractual right to adjudicate. The key that emerges from the Supreme Court decision is that enforceability is going to be key. The Supreme Court rightly recognised that there may still be issues for insolvent parties at enforcement stage, and it's clear that the Meadowside exceptions are going to be critical for the parties. For insolvency practitioners and those acting on behalf of insolvent parties, the issue of funding is going to be paramount in the enforcement stage. Questions such as will it be available and whether the level of funding will be available to meet the requirements is going to be key. In terms of what the future holds following Bresco, well, clearly there will be no more injunctions restraining adjudications, and there's likely to be a pent-up demand of parties waiting to commence adjudication proceedings pending the Supreme Court decision. With the recession, it's also very likely that there will be a further increase in adjudications on behalf of insolvent parties. And this adjudication process is going to be good news for insolvency practitioners because it presents them with a cost-effective and speedy methodology of resolving disputes for the interests of their creditors. However, as I've said more than once during this presentation, the enforcement stage will be key, and it will be paramount importance that liquidators who want to enforce decisions can show that they have the security in place for the costs and also ring fence any proceeds. So it'll be interesting to see how the Technology and Construction Court grapples with the first enforcement case once it comes before them. However, in the meantime, I believe it's a case of watch this space, and no doubt in future updates, we'll have further updates for you. Thank you.
Excellent. Thank you very much, Martin. Now over to you, Melissa, to talk about one or two other things that have been happening outside of Bresco.
Thanks very much, Jeremy. Martin has made this very difficult, but my job today is to try to convince everyone that it's not all about Bresco. And hopefully you'll have noticed that I've set myself a deliberately low bar. So if you end up today thinking it's mostly, but not all about Bresco, I'll consider that a win. So I'm going to look at two cases that you might have missed in the overwhelming excitement of Bresco. The first case is MW and Balfour Beatty. This case is all about crystallisation, which is why I think it's interesting. It's now very rare to see challenges to enforcement that are solely about crystallisation. So firstly, the facts. MW employed Balfour Beatty to carry out mechanical and electrical works in relation to the construction of a new laboratory in Hull. The contract was a JCT design and build subcontract, 2011 edition with bespoke amendments. Delays arose, including in relation to the Section 3 works, and the works were divided into several different sections. Balfour Beatty issued several notices of delay going all the way back to March 2018. There was no response from MW, which, as I'll return to at the end, probably didn't help to paint them in the best possible light. On the 30th of July 2019, Balfour Beatty sent MW a delay expert report, and that was the Goodman report. That report analysed the delay to the Section 3 works and included a detailed critical path analysis. Just 8 days later, Balfour Beatty commenced an adjudication. The dispute was in relation to Balfour Beatty's entitlement to an extension of time for the Section 3 works. The adjudicator awarded Balfour Beatty the full extension of time claimed. The issue was whether a dispute had crystallised between the parties. MW argued that it was entitled to 16 weeks to assess a claim under the contract. No dispute could therefore have crystallised because a reasonable time had not elapsed after the submission of the Goodman report for MW to consider the claim and either accept it or reject it. 8 days, and I imagine a lot of people have sympathy for this, they argued was clearly insufficient. There were 4 relevant contractual clauses. First, under clause 2.17.1, Balfour Beatty had to notify MW forthwith if and whenever it becomes reasonably apparent that the commencement, progress, or completion of the subcontract works is being or is likely to be delayed. Secondly, under clause 2.17.2, Balfour Beatty had to give particulars of the expected effects of the events notified in the clause 2.17.1 notice. Thirdly, under clause 2.17.3, Balfour Beatty had to forthwith notify MW of any material change in the estimated delay or any other particulars. And finally, under clause 2.18.2, MW had to notify Balfour Beatty of its decision on an extension of time as soon as reasonably practicable, and in any event, within 16 weeks of receipt of the required particulars. So to summarise those four clauses, there's a notification provision, there's a provision for the supply of particulars, and then there's a time period within which MW had to make a decision. And you'll have seen similar contractual provisions in other standard form contracts like FIDIC, for example. So that's the facts and the contract. Moving on to the exciting stuff, the law. The headline point, which I appreciate is perhaps a bit of an anticlimax, is that there is no new law in MW. The decision was based on the two key cases on whether a dispute is crystallised, which I've put on the slide by way of recap. And they are Mr. Justice Jackson's, as he then was, 7 propositions in AMEC, and the guidance in Cantillon and Bresco. With those cases in mind, what the court had to decide was whether the additional information in the Goodman report, objectively assessed, gave rise to a new claim. The court said no. It, and that's the Goodman report, contained a detailed critical path analysis, and the total extension of time claimed was marginally longer than the previous cumulative extension claimed, but it was not materially different to the delay claim advanced in the earlier notices that had been issued by Balfour Beatty. The court went on to say that the Goodman report was evidence by way of expert analysis to support Balfour Beatty's claim for an extension of time, in respect of which there was a crystallised dispute. So the court there was clearly drawing a distinction between evidence and the claim itself. So to summarise, I think there are 2 key points to take away from MW. One, there's no new law. The starting point when you're considering whether a dispute is crystallised is still AMEC and Cantillon and Bresco. And 2, this is a practical point, but I think it's an important one, respond after taking appropriate legal advice, if needed, to delay notices. Do not bury your head in the sand, because that's unlikely to make anything any better. Moving on to part 2 of my quest to persuade you it's not all about Bresco, and that's severance. This is a Scottish case, Dickey and Moore Limited and McLeish. It's well worth reading, particularly because it contains a really useful analysis of the English authorities on severance. In McLeish, the Scottish version of the scheme for construction contracts applied. The court accepted that the adjudicator didn't have jurisdiction in relation to an extension of time claim and the associated loss and expense, because a dispute had not crystallised in relation to those items. The question for the court was whether there were any other aspects of the decision that could be enforced. Interestingly, the court's reasoning was really underpinned by what they said the purpose of the scheme was. And the court summarised that as enabling contractors and subcontractors to obtain payment of sums to which they've been found due without undue delay. The court went on to say that where you have an adjudicator's award that is partially valid and partially invalid, the valid part should be enforced if that's realistically practicable. They went on to say, in approaching severance, the court should adopt a practical and flexible approach that seeks to enforce the valid parts of the decision unless they are significantly tainted by the adjudicator's reasoning in relation to the invalid parts. So applying that practical test, the court found that the extension of time claim and the associated loss and expense, as I mentioned at the start, would not be enforced, and neither would the aspects of the decision that flowed from that, such as liquidated damages. But all other aspects of the adjudicator's decision, such as payment for measured works and additional works, would be enforced. They were, the court found, untainted by the decision and reasoning in relation to the extension of time claim. So on that note, I hope I've been at least partially successful in my aim to persuade you that it's not all about Bresco, and I will hand back to Jeremy.
Excellent. Thank you very much, Melissa. As I said at the beginning, we did want to have a quick look and think about adjudication generally in 2020. And so we're going to engage in a tiny bit of quick crystal ball gazing even. And there's sort of 4 issues that we could possibly consider. We've talked about there possibly being more disputes. Will that simply mean that there are going to be more adjudications? If there are more adjudications, does that mean we need more adjudicators? Looking at things from a different point of view, has the time come to remove the power and other industry exemptions? If you remember, there are a number of construction operations to which you can't use or go to adjudication with. And if we did that, would that be fair on residential owners and occupiers, the Section 106 exception? Martin, I don't know if you've got any views on any of those 4 points.
Yeah, I think there will inevitably be more adjudications as there are more disputes. I think adjudication as a process has shown itself to be quick, cost-effective, and in particular in resolving disputes in terms of cash flow, it can be effective for the parties. Well, I think bearing in mind the Adjudication Society's research showed that over 90% of adjudications concern payee versus payer. I think that is going to be the root of most disputes in the future. In terms of the exceptions, I think adjudication has moved on quite a bit since its inception, and the disputes it was perhaps originally envisaged that it would be resolving. I think it is perhaps time to have another look at those exceptions to see if they're still suitable, and perhaps they fall within the ambit of adjudication. In terms of the residential occupier exclusion, I feel that's perhaps an exclusion that should remain in place.
Okay, Melissa, is there anything you'd like to add?
Yeah, I suppose I feel most strongly about the third point that you've raised, Jeremy. I think the time has now definitely come for Parliament to reconsider the exceptions in Section 105. As far as I can see, there's no real logic to the list. And as Martin said, it was drafted at a time when no one knew how successful adjudication would be. And now it's proved itself to be a success. I think it's time for Parliament to reconsider that list.
Okay, now that's interesting. I'll address the second point because I do think that there will be more adjudications because it looks like there are a number of disputes, and that adjudication, as you've both said, is a good way of resolving those disputes. So more adjudications need more adjudicators. So it's the perfect time to open up the adjudicator nominating body lists. I mean, I think it's a great time, and there's the chance now to make those lists more diverse, to reflect properly the industry that we are all working in. So there's an opportunity there, and I think it's an opportunity that the nominating bodies would do well to seize. So there's just time for a few questions. I'm afraid, Melissa, that most of the questions are related to Bresco. So you may have failed on your mission to persuade people that there were other cases as important as the Bresco one. But there we go. But maybe I'll ask the first one to Martin. Do you think that Bresco was at least in part an endorsement of adjudication by the court, and that endorsement was driven to some degree perhaps by the COVID-19 lockdown and the fact that adjudication can be a good way of resolving disputes, partly because it can be done totally online?
Yeah, I don't think the Supreme Court itself was necessarily influenced by the procedure and COVID-19 and adjudication's ability to conduct itself in those trying conditions, but I certainly do believe that adjudication has shown itself adept to during this lockdown as a method of resolving disputes, and adjudications have essentially continued unabated. There have been one or two challenges to adjudications going on during the COVID-19 pandemic, but they've been unsuccessful. So I think adjudication is here to stay, and it's shown that it can withstand even the most trying circumstances.
Okay, thank you. Melissa, I'll try one on Bresco on you.
Okay.
It's a little bit different to what Martin has been focusing on, but it's one of the issues that there's certainly been some discussion about. People have picked up one or two comments that were made by Lord Briggs about disputes and multiple disputes, or whether there should be whether the time has come to end what some people call the one dispute rule. And just wondering if you've got any views in light of the comments made by Lord Briggs, whether the time has come that a referring party can now refer multiple issues to adjudication with, shall we say, relative impunity.
Thanks, Jeremy. I think in typical lawyer fashion, I'm going to try and diplomatically sit on the fence on this one, if you'll let me. I think on one hand, paragraph 8 of the scheme, which Lord Briggs cites in that section of the judgment, clearly says that an adjudicator can only, with the consent of the parties, adjudicate on more than one dispute. And in his analysis of the single dispute rule, Lord Briggs actually went on to look at some of the previous case law on the single dispute rule, such as Witney Town Council and Beam. And those cases clearly establish that where there are distinct disputes, only one can be referred to the adjudicator. So I think actually if you read that section of the judgment as a whole, it doesn't seem to me like Lord Briggs was intending to depart from the previous case law on whether there's a single dispute. So I think the prudent approach must be to continue to refer a single dispute. That said, and the fence-sitting bit, I absolutely do think we will see submissions based on that paragraph of Lord Briggs's judgment in the future, and I'll stay diplomatically quiet on whether I think they're likely to succeed, just in case I have to argue them in the future myself.
Yeah, I mean, I certainly agree with you that people will see the comments as a potential opportunity. Martin, still with Bresco, you talked, I think it's more Meadowside perhaps than Bresco itself. You talked about the need to put security in place, and people wondering what sort of securities that might be. I mean, are we talking maybe bonds, payments into court, or a mixture of the two?
Possibly a mixture of the two, or possibly insurance policies that provide coverage. I think of an insurance policy that shows that it would respond in those circumstances, and an insurance policy whereby the insurer could not change the terms if it looked like the prospects were substantially changed would be appropriate. And I think that's the sort of thing that found favour in Meadowside and Aztec.
Okay, yeah, you're absolutely right about insurers. I think one of the points that's notable from the Meadowside judgment is that the insurers were actually sitting there in the court. So it just demonstrates this. I mean, that's insurance, perhaps more than bonds and payments in court, but it can be a mixture. It's whatever works, I suppose, for the parties in question. There's just one final point that I will deal with. We've had 2 or 3 comments and questions about the process and procedure of adjudication. And sometimes they're a difficult question to answer because they're going to be very specific on the facts of each individual adjudication. But people are concerned, I think, going through the adjudication process, when you get rejoinders and surrejoinders and whatever you call the document that follows the surrejoinder, and what happens and how is that fair, and what should the adjudicator do? And to be honest, the answer is it does depend on the facts of the adjudication. An adjudicator must always be aware of the basic rules of natural justice, which has given both parties a fair opportunity to be heard, an equal and fair opportunity to be heard. And you need to balance that against the fact that adjudication is still a relatively swift process, 28 days, 42 days, maybe a little bit longer. And the adjudicator still has to write their decision. So I think if I was wearing my adjudicator's hat, I would be anxious to ensure that both parties had a fair opportunity to respond. but I'd also be aware that at some point I have to draw a line. And it's up to, I think, an adjudicator to take a reasonably firm hand in drawing that line. And I think they'll get some support from the courts. From my acting for a party's point of view, I think a good rule of thumb to bear in mind is it's very rare that your best point is made in your third or fourth submission. So always make sure that your good points are made up front. And so sometimes people, and there's always going to be exceptions, but sometimes people think that the rejoinder and the surrejoinder and all the other documents take on a greater importance than they perhaps need. And the key is always to be thinking about how are you going to present your case in the referral? How are you going to present your case in the first reply document? Because I think that's the key thing. That's where you need to get your key points in. But thank you very much, everyone, for attending, and thank you very much for all your questions, which are much appreciated. And thank you to Martin and Melissa for your presentations, which I thought were very clear and very helpful. Just remains for me to note that next week, complete change of pace, change of discussion, and my colleague and fellow partner John Miller will be joined by Glenn Horton, and they'll be looking at fire safety in tall buildings, both from a technical and a legal point of view. So hopefully you'll come and join us then. So thank you and goodbye.